Welcome back, everyone, to another deep dive. I always look forward to these, and today is no exception. We're diving into the world of Indian law. Well, specifically, the legal profession itself, how it's structured, how it's evolved over time. And let me tell you, we've got a ton of material. We're looking at the Advocates Act of 1961, which, if you're not familiar, is a pretty substantial piece of legislation. But don't worry, we're not going to get bogged down in every single detail. Our mission is to extract the most interesting, the most insightful parts, so you can walk away with a clear picture of how the Indian legal profession came to be what it is today.
It's a long story, I have to admit. It goes way back. We're talking ancient roots here. Even in the Hindu period, we see evidence of a legal profession, though it's certainly not the structured system we have now.
Right, right. So we're talking about the very concept of having someone represent you legally. That goes back that far.
Absolutely. Then, as we move into the Muslim period, things start to take a bit more shape. You have legal representatives who are known as vakils.
Vakils. Interesting. So the term itself has some history to it. But then, of course, the British era arrives, and that feels like a real turning point. We've got the charters of 1726, 1756, and then 1774. These seem pretty pivotal in shaping what came after. What was the real significance of these charters?
Well, those charters, they laid the groundwork for the court system we have in India today. The 1726 charter was the first one to establish royal courts, which introduced a more, structured legal process. But the 1774 charter, that was a big one.
That's the one that established the Supreme Court of Judicature in Calcutta, right?
That's it. It was the arrival of a distinct judicial body operating under British law. Then later, similar Supreme Courts were set up in Madras in 1801 and in Bombay in 1823. So you can see how it really spread.
So it wasn't just a little tweak to the existing system. This was about creating a whole new judicial framework and then replicating that framework across the major presidencies. And then after that, we have a series of legislative acts. The Bengal Regulations Act of 1793, the Indian High Courts Act of 1861, the Legal Practitioners Act of 1879. It really seems like they were constantly refining the system. What was driving all of this? Were there specific problems they were trying to address?
Right. The 19th century was really about solidifying and regulating things. The Indian High Courts Act of 1861, that was huge. It unified all the existing judicial systems under these newly established high courts, the Sadar courts, the Supreme Courts, and the presidencies. All of that was replaced. Then, the Legal Practitioners Act of 1879, this started to address who could actually practice law. It was the first real attempt to regulate the qualifications and the conduct of legal practitioners.
So this is where we start to see the profession becoming more organized, more defined. And then, as we move into the 20th century, the push for a more unified and organized profession continues. You have the Indian Bar Committee in 1923 and the Indian Bar Councils Act of 1926. What were the big ideas that emerged in this period? What were they trying to fix?
Yeah, the 1923 committee, they hit on something really important. They saw that the legal profession was really fragmented. You had all these different grades of practitioners, advocates, vakils, pleaders, and so on. And each of them had different privileges, different status. And they said, this is a problem. They proposed a single grade for everyone, and they wanted everyone to be called advocates.
A single unified profession. Sounds like a radical idea for the time.
It was. And the Indian Bar Councils Act of 1926, that was the first real attempt to implement this idea. It aimed to unify these different groups, though it didn't fully achieve the goal of a single bar.
But it was a step in that direction.
Right.
Okay, so we have this idea of unity and standardization gaining momentum. Then we come to the All India Bar Committee of 1951, headed by Justice S.R. Das. What were their key arguments, and how did their work set the stage for the modern legal profession in India?
This committee was bold. They really went for it. They said, we need to abolish all these different classes of legal practitioners. No more vakils, no more pleaders, just advocates. And they made another big recommendation. They said, to become an advocate, you need at least 2 years of law study after graduation. This was about raising the bar, ensuring everyone had a solid foundation in law.
A real push for professionalism. So they're saying we need to move away from these informal, non-standardized practitioners.
Exactly. People like Mukhtars, there were concerns that many of them didn't have the same level of legal knowledge.
It makes sense. You want everyone in the profession to have a certain level of competence. And the 14th Law Commission, they supported these recommendations, right?
They did. They said, yes, these reforms are necessary.
Okay, so we have all this groundwork laid, and it feels like we're heading towards a major shift. This is where the Advocates Act of 1961 comes in. It seems like the moment where that vision of a unified profession finally becomes a reality. What was the main goal of this act? What did it achieve?
The Advocates Act of 1961, it was a game changer. It did a few things. It consolidated and amended all the existing laws relating to legal practitioners. But more than that, it established a unified bar, not just in one state, but across the whole country. It brought the legal profession together, and it also created the bar councils at the state level and the national level, the Bar Council of India.
So it's not just about bringing everyone together under one title. It's about creating structures for self-governance.
Yes, the profession could now regulate itself, set its own standards, manage its own affairs. This was a big shift in power, from the courts to the bar councils.
So the act creates this unified framework, empowers the profession to regulate itself. But to understand all of this, we need to define some key terms. Let's start with the most basic. Who is an advocate under this act?
An advocate is someone whose name is on the roll, the official list of advocates maintained by a state bar council. That's the simple definition. If you're on that roll, you're an advocate. You're licensed to practice law.
Straightforward enough. And then there's this term, appointed day.
Right. The appointed day refers to the specific date when a particular part of the Advocates Act came into effect. You see, the act wasn't implemented all at once. It was done in stages. So different sections of the act have different appointed days.
Okay, that makes sense logistically. Now, what about Bar Council versus Bar Council of India? What's the difference there?
Each state has its own bar council. This council is in charge of enrolling advocates in that state, managing any disciplinary proceedings, and generally safeguarding the rights and interests of the advocates in that state. The Bar Council of India, however, is the big boss, the national body.
The head honcho.
Yeah, they're the ones who oversee all the state bar councils, make sure they're all on the same page. They set the standards for legal education across the country. They define professional conduct and basically act as the guardian of the profession.
So the state councils handle local matters. The national council sets the overall standards. Got it. Now, what about law graduate? What qualifies someone as a law graduate under the act?
Simply put, you have to have a bachelor's degree in law from an Indian university that's been established by law. That's your ticket to entry.
And finally, legal practitioner. This one seems a little broader, maybe encompassing more than just those who fit the definition of an advocate.
You're right. Legal practitioner is a more inclusive term. It includes advocates, vakils from any high court, though that term is basically the same as advocate. Now that gets interesting. It includes people who are known as pleaders, muktars, and even revenue agents.
Remnants of the old system.
Exactly. This was the system before the Advocates Act came and swept it all away.
Which takes us back to the pre-1961 landscape. Our sources mention the Pleaders, Mukhtars, and Revenue Agents Act of 1865. What was the system like? How did it classify legal professionals?
It was a more complex system, more hierarchical. The 1865 Act, it divided legal practitioners into 6 grades: advocates, solicitors, vakils, pleaders, mukhtars, and revenue agents. And each of these grades had different qualifications, different courts they could practice in, different levels of recognition. It wasn't as simple as it is now.
Okay, let's focus on the now defunct categories of mukhtars and revenue agents. What kind of work did they typically do? What were their qualifications?
Most mukhtars, they practiced in the lower criminal courts, the subordinate courts. They handled more minor cases, you could say. Revenue agents, on the other hand, they dealt with land revenue matters, primarily in revenue courts and offices. The interesting thing is that many of them didn't have formal legal training.
No law degree.
Nope. A lot of them were just matriculates, meaning they had completed their secondary school education, but that was it.
Wow, so someone with just a high school education could represent people in court? That seems like it could be problematic in terms of ensuring quality representation. Were there any mechanisms to regulate them or to ensure some level of competence?
Yeah, the Legal Practitioners Act of 1879, that brought in some regulation. It gave the high courts the power to set rules for enrolling mukhtars. And these rules usually included having to be at least a matriculate and passing an exam, a mukhtarship exam, conducted by the high court. It wasn't a law degree, but it was something.
So a step towards some standardization.
Right.
And were there any grounds for disqualifying a mukhtar? It seems like that would be important, especially given the limited formal training.
Oh, yeah, there were quite a few grounds for disqualification. Things like being convicted of a criminal offense that showed bad character, taking instructions from the other side in a case, accepting instructions from unauthorized people, people who weren't actually representing a party. Also things like fraud, improper conduct, withholding payments that were due to other mukhtars. And of course, if they got their position through bribery, that was grounds for disqualification. Basically, anything that showed they weren't fit to practice.
Makes sense. Okay, let's move on to pleaders. Where did they fit into all of this, and what set them apart from Mukhtars?
Pleaders were a step up from Mukhtars. They were either law graduates who, for whatever reason, couldn't enroll as advocates or vakils in the High Court, or they were people who had passed a special pleadership exam. The main difference was that they could practice in the subordinate courts, but not in the High Court, at least not initially.
So a bit more qualified than Mukhtars.
Right. But not quite at the level of advocates and vakils of the High Courts.
So they typically had a law degree or had passed a specific exam. And were there disqualifications for pleaders as well?
Oh yeah, very similar disqualifications to Mukhtars. Things like criminal convictions that showed bad character, unethical dealings with the other side, fraud, bribery, accepting work through touts, and, again, a general clause for any other good reason why they shouldn't be allowed to practice.
Okay, so we have this multi-tiered system, but it's clear there's a push to streamline things, to raise the bar for everyone. And this is where the Advocates Act of 1961 comes in again. How did it simplify the classification of advocates?
It got rid of all the old classifications from the 1865 Act. No more 6 grades, no more Mukhtars, no more pleaders. The 1961 Act just said you're either a senior advocate or an advocate. It was a huge step towards unifying the profession.
A much clearer system.
Yeah.
Now let's talk about senior advocates. What does it take to earn that designation under Section 16 of the Act?
Well, to become a senior advocate, you need to be designated as such by the Supreme Court or a High Court. But it's not something you apply for. They choose you. They look at your ability, your reputation, your experience, your expertise in a particular area of law. And if they think you deserve it, they'll offer you the designation. You have to agree to it, of course.
So it's an honor, a recognition of your achievements.
It is.
What about those who were already considered senior advocates in the Supreme Court before the Act came into effect? What happened to them?
They were automatically considered senior advocates under the new system. They didn't have to go through the whole designation process again. But they did have the option to say, no thanks, I don't want to be a senior advocate anymore.
Interesting. Okay, so becoming a senior advocate is a big deal. But it's not just an honorary title, right? There's certain restrictions that come with it.
Right. Part 6 of the Bar Council of India rules, they lay out these restrictions. For example, a senior advocate can't directly file a vakalatnama, which is the document that authorizes them to act for a client. They can't act independently in court either, or in tribunals, or before any authority mentioned in Section 30 of the Act.
So there are limitations on their practice. Why is that?
Well, one reason is to encourage collaboration within the profession. When a senior advocate appears in the Supreme Court, they have to have an advocate on record with them. In other courts, they need a junior advocate. And they can't accept instructions directly from clients. Everything has to go through another advocate. The idea is to ensure that more junior members of the bar get experience, get involved in important cases.
It's a way of fostering mentorship and professional development.
Exactly.
Okay, let's shift gears now. We've talked about advocates in general, senior advocates, but there's another category of legal professionals that's crucial to the system: the lawyers who are appointed by the government. This is a whole other area, and it's important to understand how it works.
Absolutely. The Constitution itself establishes several key legal officers for the government, starting with the highest one, the Attorney General of India. Articles 76 and 78 of the Constitution, that's where you'll find the details about their role and responsibilities.
Okay, so top of the heap, the Attorney General. How is this person appointed, and what qualifications do they need?
It's the President of India who appoints the Attorney General, but they do it on the advice of the Union Cabinet. And to be eligible for this position, you need to be a citizen of India, and you need the same qualifications as a Supreme Court judge.
So pretty high bar there.
It is. You either have to have been a judge of a high court for at least 5 years, or an advocate of a high court for at least 10 years, or the president can decide that you're a distinguished jurist.
So you need serious legal chops to even be considered. And what does the Attorney General actually do? What are their responsibilities?
They're the main legal advisor to the government of India. They advise the president on any legal matters that come up, especially when it comes to those presidential references under Article 143, which deals with questions of law or fact. They represent the government in all cases before the Supreme Court, and they have the right to appear in any court in India.
So they're the government's top lawyer, basically. Do they have any special privileges?
Well, they have the right to participate in the proceedings of both houses of parliament and any committee thereof, but they can't vote.
Interesting. Speak but not vote. So are they considered a government employee?
No, they're not a full-time government servant. And they are allowed to have their own private practice as long as they don't appear or advise against the government.
Makes sense. You wouldn't want them arguing against the government they're supposed to be advising. Now, the Attorney General has an assistant, right? The
Yeah.
Solicitor General.
Yeah. That's right. The Solicitor General is the second highest law officer in the country. They're appointed by the government for a 3-year term. And unlike the Attorney General, whose position is established by the Constitution, the Solicitor General's position is established by law. The Appointments Committee of the Cabinet, they decide who gets the job.
And what does the Solicitor General do? How do they help the Attorney General?
They advise the government on legal matters. They appear for the government in the Supreme Court and the high courts. They handle those presidential references and basically do any other legal work the government needs them to do. They share the load, you could say.
Okay, so they're like a Deputy Attorney General.
Right.
And are there restrictions on their private practice as well?
Oh, yeah, quite a few. They can't represent anyone other than the government in court, and they can't advise anyone against the government or a public sector undertaking without permission from the law ministry. There are also rules about defending people in criminal cases and accepting positions in companies. It's all about avoiding conflicts of interest.
Right, so their primary loyalty has to be to the government. Now, let's go down to the state level. We have the Advocate General of a state. Is this basically the state-level equivalent of the Attorney General?
You got it. The Advocate General is the top lawyer for the state government. It's a constitutional position, just like the Attorney General, and they're appointed by the governor. They serve as long as the governor wants them to.
So what are the qualifications for this position?
Well, you need to be a citizen of India, and you need at least 10 years of experience as a judge or as an advocate of a high court. So similar to the Attorney General, really.
Okay, and what does the Advocate General of a state actually do?
They advise the state government on legal matters. They represent the state in court. They can speak in the state legislature but can't vote. They basically act as the guardian of the Constitution within the state.
It's like a mini Attorney General, but for the state. Now, we also hear about government pleaders. What do they do?
Government pleaders, they're lawyers appointed by the state government to help out the Advocate General, the state prosecutor, and other government lawyers. They handle things like giving legal advice to government officers, helping with document registration, preventing people from evading stamp duty, appearing in court, and doing other legal tasks.
So they're like the support staff for the government's legal team.
You could say that.
Okay, and then there are public prosecutors. What's their role and how are they appointed?
Public prosecutors are appointed by the state government. Their job is to prosecute criminal cases on behalf of the government. They present evidence, argue in court, supervise judgments, advise the police, and do all the things that need to be done to make sure the government side of a criminal case is presented effectively.
So they're the ones who actually go to court and fight for the government in criminal cases.
Precisely.
And there's also the concept of a special public prosecutor.
Right. The central government or a state government can appoint a special public prosecutor for a specific case, usually if it's a high-profile or complex case.
Okay, so those are the main government lawyers. But there are a couple of other legal roles that are interesting, even though they're not government appointments. What's an amicus curiae?
Amicus curiae is Latin. It means friend of the court. It's a person or an organization that's not directly involved in a case, but the court asks them to provide information or expertise that can help the court make a decision. They're like a neutral expert.
So they're there to help the court, not to represent one side or the other.
Exactly.
And finally, what about a notary public? What do they do?
A notary public is appointed by the government, either central or state. Their job is to authenticate documents, like deeds and affidavits and things like that. They check the identities of the people signing the documents, they witness the signatures, and they basically make sure the documents are legally valid.
So if you need a document notarized, you go to a notary public.
That's right.
Okay, we've covered the various types of legal professionals in India, but what about the rights of advocates themselves? What are some of their fundamental rights?
Well, the most basic right is the right to practice law. This means they have the right to appear in court, to represent clients, to plead cases. This right is enshrined in the Constitution, and it's specifically mentioned in the Advocates Act as well.
So if you're an advocate, you have the right to practice law, to do your job.
Absolutely.
And there's this thing called the right of pre-audience. What is that all about?
The right of pre-audience. It's about who gets to speak first in court. It's laid out in Section 23 of the Advocates Act, and it creates a hierarchy. The Attorney General is at the top, then the Solicitor General, then other law officers, then senior advocates, and then other advocates.
There's a pecking order.
Right. The more senior you are, the earlier you get to address the court.
Okay, so advocates have rights, but they also have responsibilities. What are some of the main duties that advocates have to uphold?
They have a duty to the court, which means they have to be respectful, act with dignity, follow the rules, dress appropriately, and avoid conflicts of interest. They also have a duty to their clients, which means they have to accept briefs, represent their clients' interests, charge fair fees, and not hide any evidence.
So they have to be ethical and professional.
Exactly.
What about their duties to their opponents and to other advocates?
They can't negotiate directly with the other side without their lawyer's permission. They have to keep their promises, they have to treat each other with respect, and they have to avoid conflicts of interest. They're also not supposed to advertise or solicit work.
It's about maintaining the integrity of the profession.
Right.
And what about their duties to the profession and to society as a whole?
Well, they have to uphold the dignity of the profession, promote legal education, maintain high standards of conduct, avoid making misleading statements, and respect the bar councils. As for society, they have to promote access to justice, uphold the rule of law, provide legal aid, educate the public, and serve in public office if called upon.
So it's not just about individual cases, it's about the bigger picture. Now let's talk about something that's often a bit controversial. Restrictions on other employment for advocates. What are the rules there?
The Bar Council of India rules. They lay it out pretty clearly. An advocate can't be involved in any business except as a sleeping partner with permission from the Bar Council. They can't have a full-time job either unless they're a government lawyer.
So the idea is to prevent conflicts of interest.
Exactly. They can inherit a family business, but they can't actively manage it. And they can do things like review bills, edit textbooks, coach students, teach, as long as it doesn't interfere with their practice. But part-time employment is only allowed with permission from the Bar Council.
Okay, so there are rules, but there's also some flexibility.
Right.
Now, what are some of the key ingredients for successful advocacy? What makes a good lawyer?
Well, Supreme Court Justice Unu Lalit has said it best. Focus on the facts and the law. Don't get caught up in emotions. Stick to the evidence and the legal principles. That's what makes a strong case.
Solid advice. So what about courtroom etiquette? How are advocates supposed to address the court?
It's all laid out in the Advocates Act and the rules. In the Supreme Court and high courts, you say, Your Honor or Honorable Court. In the lower courts, it's Sir, or the equivalent in the local language.
So there's a formal protocol.
Absolutely.
What about retired judges? Can they still be involved in the legal system?
Yes, they can. The Chief Justice of India can ask a retired Supreme Court or High Court judge to come back and act as a Supreme Court judge for a while. But it's only temporary, and they need the president's permission.
So it's a way of tapping into their experience.
Right.
Now, what about examining witnesses in court? There are different stages to that, right?
Yeah, there's the chief examination, where the lawyer who called the witness asks them questions. Then there's cross-examination, where the other side gets to question the same witness. And finally, there's re-examination, where the first lawyer can clarify anything that came up during cross-examination.
So it's a back and forth.
It is.
Now, what constitutes illegal practice trial advocacy? What are lawyers not allowed to do in court?
It basically means doing anything illegal or unethical during a trial, breaking the rules, violating the law, that kind of thing. And there can be serious consequences, including disciplinary action or even jail time.
So there are limits.
Definitely.
Okay, our sources talk about the Panchashil of the bar and the 7 lamps of advocacy. What are these?
There are sets of principles for advocates. The Panchashil is about honesty, hard work, justice, service, and philosophy. The 7 lamps are similar, but they also include courage, wit, eloquence, and fellowship.
So they're like ethical guidelines.
You could say that.
Now let's tackle a tough one, lawyers' strikes. What's the legal position on that?
It's a complicated issue. Some lawyers say they have the right to strike, but the Supreme Court and high courts have consistently said that lawyers' strikes are illegal. They disrupt the courts, and they prevent people from getting justice.
So strikes are a no-go.
Generally, yes. The Bar Council of India is also supposed to prevent lawyers from striking.
And there have been some important court cases about this, right?
Yeah, lots of them. The Harish Epple case said lawyers can't strike or boycott, but they can protest in other ways, like giving interviews or holding peaceful demonstrations. The Hussein case reaffirmed that strikes are illegal. The Roman Services case said courts don't have to wait for striking lawyers. And the Wadhira, Tamrakar, Common Cause, and Pandy cases all basically said the same thing. Strikes are bad, don't do them.
So the message is pretty clear.
It is.
And what happens if a lawyer does go on strike?
They can face disciplinary action, which could include suspension or even being disbarred.
So there are consequences. Have there been any suggestions for alternative ways for lawyers to express their grievances?
Yeah, the Supreme Court has told the high courts to set up grievance redressal committees where lawyers can raise their concerns. And they've also said that lawyers can protest in ways that don't disrupt the courts, like holding peaceful demonstrations or issuing press statements.
So there are other options. Well, we've covered a lot of ground today. We've gone from the ancient roots of the legal profession in India to the modern unified system under the Advocates Act of 1961.
We've seen how the profession has evolved, how it's become more organized, more standardized, more self-governing.
And we've explored the many roles that legal professionals play, from representing clients to upholding the Constitution. It's a complex and fascinating profession with a huge impact on Indian society.
It is.
And as we saw with the issue of strikes, it's a profession that's still evolving, still facing challenges, still striving to find the right balance between its rights and its responsibilities.
Absolutely.
So here's something for you to think about. How can the legal profession in India continue to adapt and improve to meet the needs of a changing society and to ensure that justice is truly accessible to everyone? It's a question worth pondering. Thanks for joining us on this deep dive.